Hey, it's Rob Ryder, and it's Monday, July 21st, 2020. Counselor at Law. It's my new favorite officer of the court. I just need to find one. Because I'd like to file a SCOTUS, Supreme Court of the United States, Rule 40, which is a veteran petition. And the way I read it, that's the person I need. And that's mainly what this video is about, is why I believe that to be so. And maybe between all of us veterans, we can find one of these jokers. And then I'll show you some things that you could use it for. But basically, the petition would be, we're not going to the Supreme Court to petition for certiorari. We're going to go petition for redress of grievances under the First Amendment. So we'll get to that in a minute. But because I was doing this video, what President-elect Trump needs to know. And that's because, of course, President-elect Trump hasn't taken the 2 oaths of office he needs to take to be the Commander-in-Chief and the President of the United States, which I've done many videos on, and if you were just to search for upload date, you could see just the last couple of videos I was talking about that. But what I want to point out to President-elect Trump, so if you have his ear, can get his attention, can get any of these, high-ranking muckety-mucks' attention, would you please tell him that about the oath to foreign masters that federal workers are taking. Because when you look in their Constitution for the Union, they're taking an oath. And on top of that, they're not properly taking the oath they should take to satisfy the 6th article of the Constitution. So they're not under a promissory oath to the Constitution because it was done wrong, but they are under a promissory oath to their frickin' Union. Well, there's just something wrong with that, don't you think? And then President Andrew Johnson's Amnesty Proclamation of May 29, 1865, which has this nice little oath that we could take to say, hey, we're not part of the problem. And he had given orders in this proclamation for the Secretary of State to come up with the rules to do so. So where are the rules? President-elect Trump, right? That's what I want to do. I want to take the oath that's in Andy Johnson's Amnesty Proclamation. Excuse me, President Andrew Johnson. Doesn't matter, he's an old, well, back in the day. You got to treat him with proper respect. President Andrew Johnson, Amnesty Proclamation of May 29, 1865. Which had been like, just soon after Lincoln had been assassinated. And because I had to throw this in, because I had found it, and it's like, well, I got to put this in video. If you go into Wikipedia and go under Mr., part of the definition will say in the 19th century and earlier in Britain, 2 graduations of gentlemen were recognized. The higher was entitled to use Esquire, usually abbreviated to ESQ, which followed the name, and the lower employed MR before the name. Today, on post from Buckingham Palace, a man who is a UK citizen is addressed as an Esquire, and a man of foreign nationality is addressed as a Mr. So when they call you a Mr., that's a title under British law, just like Esquire is. Except Esquire, ESQ, is a UK citizen, and a Mr. isn't a UK citizen. But they're both being on post for Buckingham Palace. So, you're working for Buckingham Palace, basically. It's almost like you're a spy for Buckingham Palace. You're a foreign national working for the Queen as a Mr. Well, that'd make you an enemy of the state. Here we are today. It's kind of how it worked. But that's going to have to wait for more in another video because these videos get too long. But I do have to say, if you wanted to email me about something, that's courtofrecord@AOL.com. You can always use the phone, 616-712-6179. I'll try to answer as many as I can. If you can help keep the lights on, that would be wonderful too. And my PayPal account is robryder@AOL.com. If you don't have an AOL account, a PayPal account, and you would like to use a credit card, if you were to email me at robryder@AOL.com and say, send me an invoice from PayPal for X amount of dollars, you got to fill in the amount, then I could send you said invoice and you could just use your credit card to pay it. It's a wonderful system. Or there's always putting it in the mail, which is Robert Allen Retluski, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341. Okay, so before we get to the counselor at law and this and how it applies to SCOTUS Rule 40, just real quick on the oath to foreign masters that the federal workers are taking and this amnesty proclamation. So give me just a second. Okay, President Trump, if you were to look at the AFGE website, you would see they're all behind Biden. But you could go there and you could search on the word Constitution and find that they have a Constitution for the American Federation of Government Employees, which is part of the AFL-CIO, affiliated with. And for those who didn't know, the American Federation of Government Employees, it's a really large union of federal employees that, according to this Constitution, are taking an oath, right? You got oath to union officers and oath to union membership. Well, how can somebody who's in the federal government be taking this oath? So let's just really quick look and see what the oath says. There's the union. Excuse me. We'll go back and see who can be a member in just a second. Oath of union membership. I, of my own free will and accord, do hereby solemnly promise and pledge my honor that I will be loyal and true to the American Federation of Government Employees, AFL-CIO. Well, how can you take an oath to the United States and take an oath to the union, right? That's like taking an oath to two different masters. It never works out well. Jesus will tell you all about it. So, you know, but there it is. If they're a member of this union, they took an oath to this union. And so the membership, all persons of the following classes with regard to race, creed, color, national origin, sex, age, political affiliation, disability, marital status, sexual orientation, or preferential or non-preferential civil service status, exempting those over whom jurisdiction has been granted to other national and international unions by AFL-CIO, and accepting officers of unions not affiliated with the AFL-CIO, shall be eligible for full membership in the Federation. All employees of the United States government and any instrumentalities of whatever nature, including military personnel of the armed forces and of the District of Columbia, and all other persons providing their personal services indirectly to the United States government, are eligible for membership in this federation. Well, how can a member of the military, the armed forces, be in a fucking union? You know, I always thought that was a no-no. I guess I don't know that I read it. It was just told to me, well, you can't be in the union, man. You're in the military. I didn't know people in the military could be in the union, sir, but there it is. Now, since this is like covering everybody, could members of Congress be in this union also? Is this where their protection is? Whatever it is, because these people, whoever these are, have taken an oath as a union member. So, you know, this is the oath that under this Constitution that they say to take. Now, under our Constitution, it doesn't say the oath to take exactly, but the 6th article says you need to take an oath to support the Constitution. As I've shown in many videos, well, what they did right after ratification of the Constitution, the first law that they passed is 1 Stat 20 from Statutes at Large. Number 1, right, page 23, well, it says 1 Stat 23, not 1 Stat 20, 1 Stat 23, which is the act that says this is the oath that satisfies the 6th article of the Constitution. And it's I, state your name, Robert Allen Rutluski. I, Robert Allen Rutluski, do solemnly swear to support the Constitution of the United States, period. Right? Nothing about United States of America, just no other things added, just that right there. And that is now in the United States Code under 4, United States Code, USC, 4, Title 4, USC 101, which in the original act said that all officers of the state had to say it, and in this particular code it says it again, that any officer in the state, like the state of Michigan, before they can exercise any of the powers of their office, have to take this particular oath, which is in 4 USC 101. And there's nobody taking it. So it doesn't matter what else they did because they didn't do that. It's a no-go, and they can't go any further. They don't have any authority. And so the governor, from the governor on down in your state, nobody has any authority because none of them have taken the oath that's in Title 4, United States Code 101, which you can easily download online. I've shown it numerous times. I suggest that you do, and you show it to everybody who says they have authority and say, well, if you didn't take this oath, you don't have any authority. Because the Pharisee can say he didn't know until you tell him. Well, now once he knows, you've taken away his excuse, right? This is all out of the Bible, right? Take away the Pharisee's excuse for not knowing. And go show him the law. And then you're standing on the truth, and he isn't. He has to lie. You're standing on the truth. But back to our story. So this is the oath for the union, right? This frickin' union here, which is voting for Biden. By the way, I think we should go talk to him. Right, it's got 313,000 dues-paying members. Represented workers, 700,000 federal and D.C. government employees. Did they all take an oath to this frickin' union? And then not take the proper oath, right? Because, so now the oath that these people would be taking, if they were doing it properly, is supposed to be in Title 5 United States Code at 3331. And it looks something like this. When they get done, they're supposed to, when they actually, do this deal, they're supposed to put it on this standard Form 61 from the U.S. Office of Personnel Management. And this is supposed to be the oath right here. But the problem is that this line, I state your name, needs to be part of the oath of office. Right? They bifurcated the oath by putting this statement in here and saying that what follows is the oath. Well, that isn't what is in 5 U.S.C. 3331. That includes this right here with I, Jerome Powell, do solemnly swear, da-da-da-da. Well, these are the same words that the people pretending to be the Congress take, whether they're representatives or senators. They're taking the same words of this oath with so help me God. And so help me God is a religious test, and so this is an unconstitutional oath to start with. It doesn't satisfy the Constitution. To satisfy the Constitution, you need to take an oath that says, I, Robert Allen Rutluski, do solemnly swear to support the Constitution of the United States. Or exactly how it is in 4 U.S.C. 101. So everybody needs to take. And then if they need to take this oath also, well, this is a second oath. That's all I can tell you. Just like a state officer, they have another oath under the state constitution to take. Well, that's up to them. Well, they still had to do this one first. And not this, but the one that's in 4 U.S.C. 101. But this is the one that like an FBI agent would take, or, FDA, or, take your pick, whoever it is. The 331,000 people, or the 700,000 people that this is supposed to be representing. So they failed to take this oath. So this is like, as I pointed out in my last video, this would be like evading a promissory oath to the United States by submitting this and saying that this was your oath of office. And this person here, by the way, is the chairman of the Board of Governors for the Federal Reserve System. This is their paperwork. It's not a nobody. Right? This is the person pretending to be at the time at least, the chairman of the Board of Governors of the Federal Reserve System, who I'm sure has a middle name and he's not using it, so this really isn't his identification. So he misidentified himself. And then he didn't take an oath because the oath has been bifurcated. And so this is just simulating a legal process under color of law. It's fucking wrong from the beginning. Doesn't have a seal on it. Nothing about any expiration. Right? It just looks like it's a frickin' proper document, but it isn't. It has blanks on it. You can't have errors and omissions on on official documents and say that it's okay. If you do, you end up with a system like we have today, where they just throw something at you and say, well, that's what it says. See, it says at the top, arrest warrant, you're arrested. Doesn't matter that the rest of it doesn't have any information in it. Although they don't even bother doing that. They just, everything is done by warrantless arrest until they have you in custody. They just say you were disturbing the peace. They don't need a warrant. That's part of the game we play here in America. So, the things that Black Lives and Antifa, a lot of the things they're arguing about, it isn't that they're wrong. It's just the way they're trying to get it fixed is wrong. But everything they're saying about the things that are wrong are wrong. We got a really fucked up system in the United States. As we're finding out, and it goes way back, and here's just another piece of it. So, all right, hang on. Okay, and to show a little bit about how this idea of Esquire and Mr. are alive and well here today in the United States, which is really a union of the United States of America, the Confederation, created under the Articles of Confederation, and United States of America, which is a dominion of King George III. They're going to have this peace treaty and write a constitution and say, okay, well, this is how we're going to, share the land, basically, because we have two jurisdictions sharing the same territory. One that's owned by King George and one that's the independent, free and independent states. And part of that was under this Treaty of Peace from 1783, in which it says that here we're talking about King George, or Prince George, he's called himself the Third, with all his different titles, by the grace of God, King of Great Britain, France, Ireland, Defender of the Faith, Duke of Brunswick and Lunenburg, Arch-Treasurer and Prince Elector of the Holy Roman Empire, and of the, lowercase, the United States of America. Right? He says he owns the United States of America. Now, it isn't that it's a mistake, because, as we go through here and we'll look, we see now he's talking about United States, Crown of Great Britain, and the said United States. He didn't say United States of America. Right? And here he did say United States of America. And he's got John Adams as an Esquire. Well, that would make this John Adams, Esquire, as we just learned, a UK citizen. What did that say? What is it they're supposed to be? It says, well, we'll get to that one in just a minute. Yeah. So anyone who has Esquire after the name is a UK citizen. And if you have MR in front of your name, well, to the UK, you're a foreign national. So to Esquires, we're foreign to them. We're not in the same jurisdiction. Or, we shouldn't even be in the same venue. Okay, hang on. Alrighty. Right, John Adams, Esquire, United States of America. Then we got United States here. Then we got Ben Franklin. He's an Esquire. United States of America. John Jay, he's an Esquire. And the Minister Plenipotentiary for the said United States at the Court of Madrid. Right? Then we got United States. United States. I'm just showing you, they do make a distinction between the United States of America and the United States. They're not using either one of them all the time, so they must be different. So I think, when you, as an American, then you're considered the foreign national they're talking about from the UK as a Mr. But you're not in the United States, you're in the United States of America as an American. You're like an Indian. Right? You're not in their clique of the ones running the colony. You were here and they were over top of you. United States. So you see what I'm saying, right? We got treaty in America. Okay. United States. So that was my big thing. I'm just saying it does matter. There is a difference. So going further then, if you look at a passport, at the top it says United States of America. Well, that's King George's jurisdiction. We just learned that. Right? They weren't kidding. And if you read the top, it says the Secretary of State of the, lowercase t, United States of America, King George's jurisdiction, hereby request all whom it may concern to permit the citizen / national of the United States, not United States of America, of the United States, named herein to pass without delay or hinder, and in case of need to give all lawful aid and protection. And they have this space right here. And I've said, I believe this is where our name is supposed to be, right here. Right? If we were a citizen / national United States, our name would be here because this is going into the book. And this is on the cover. This is here out, not here in. And they have us on the freaking cover. Right? So that on this line right here should have been our name in this space right here. And it isn't. And so if you've had a passport watch and they take your passport really quick, open it up, and they're just looking really quick, and I think they're looking to see if there's a name here. If there is, you get different treatment. It doesn't matter what it says. What matters is your name in here. But instead, we're having our information put on the cover. That's the problem. Okay, so United States of America. Now, here is a certificate of naturalization that says at the top, the United States of America, which is different than United States of America, right? The T's been capitalized. It's just like what's on money. So this is a different jurisdiction than United States of America. I say this is the Confederation, the Republic, whatever you want to call it. That's what this is, the United States of America. It's where the money is, because that's, what it says on the top of the Federal Reserve notes. But when you read these certificates of naturalization, it's talking about that you had been residing in the United States, intended to reside in the United States, you're doing all this shit for the United States, but at the very end, what did you do? That you took an oath that such person is admitted as a citizen of the United States of America. Right? How come you're not admitted as a citizen of the United States? That's what it says under the 14th Amendment. The 14th Amendment doesn't talk about citizen of the United States of America. It just says citizen of the United States. They put you in King George's jurisdiction. And what Rosita found out, and I suggest this to anybody who has one of these documents, right? Contact the court, San Diego, in this case, to the clerk and tell them you want to pay for whatever records they have under your name to do with your naturalization. And what they found for Rosita is there's been a name change put in. And so she didn't have, a middle name either. It was Rosita and her last name. Well, they gave her father's name as her middle name. And somebody, without her doing anything to do it, filed paperwork to give her a middle name. And they have a copy of it at the court. But what they don't have at the court is any paperwork on her naturalization, which the district court is supposed to be the court where the records are for naturalization to become a citizen. So why that's important is because they list this court here, this U.S. District Court for the U.S. That's not the name of the fucking court of the district court in San Diego. Right? It's just something somebody made up. It's a private jurisdiction court. Basically, this stuff never left the executive branch because, it used to be Department of Justice and now it's Homeland Security, but it's all the same thing. It's all administrative under the executive branch. It's not judicial under the judicial branch, right? Because the judicial branch, the district court, is supposed to keep the records of people that become citizens of the United States. But at the one in Chicago, they don't have that, but they do have a record of Rosita changing her name, right? So I'm just saying, it'd be interesting for you all to find out what they have down there at the courthouse. And I think Rosita finally ordered hers, and we're just waiting for it to come in. Let's see what it says. Okay, I'm just trying to show you, right, that things aren't the way they look, and there's all sorts of reasons to believe that shit's been done wrong. And so how do you undo these things that have been done to you, right? Because basically, what Christina Francis did by doing this is she just took an oath to a foreign nation. So she gave up her nationality as a national citizen of the United States, and she went into the United States of America. And now she's an enemy of the state, as we all are. Has to be why when you go into courtrooms, there's gold fringed flags. Every courtroom's got a gold fringed flag. Well, it's got a gold fringed flag. That's an Army flag. It's an Army, it's a United States flag, but it's a military flag that's controlled by an Army regulation. It's an official flag. You don't just put it anywhere. And in the regulation, it doesn't say anything about a civilian court. It only talks about military courts. All righty. Okay, hang on. And one last thing on this, then we'll move on to the next subject, which is if you have a discharge, right? Look at your discharge, veteran, and it says here that honorable discharge from the armed forces of, lowercase the, United States of America. Well, how did I end up in King George's Army? Right? Because if you look at an ID card, it doesn't say Armed Forces of the United States of America. It says Armed Forces of the United States. Geneva Convention card, Armed Forces of the United States. It doesn't say United States of America on it. Now, the crazy thing about this discharge for me, first of all, this isn't the original one. I had this one changed because it had my name backwards. I thought that was the deal at the time, so I got my name changed, and they made these changes to it. But it says I was discharged the Armed Forces of the United States of America. So it's a discharge certificate from the Armed Forces of the United States of America. This is certification. This is to certify that Robert Allen Ratluski, Sergeant USAR, I don't know how I ended up in the reserves, but that's what they put on there, was honorably discharged from the United States Army. On the second day of February 1983, this certificate is awarded as a testament of honest and faithful service. Well, the thing is, I didn't. The 2nd of February 1983 is the day that I went back in the Army. I got out for a year, went back in, right? So I didn't even get a certificate until I went back in. And I don't have one as a staff sergeant, so I don't know if I have another one of these. But it says on here that I was honorably discharged from the Armed Forces of the United States of America. Well, that isn't what I went into. I was in the United States Army. So, it's like I was serving for a foreign government or something like that, and well, that can cause you problems, as it did back in the day during the Civil War. And so more on that in a bit, but that's what this amnesty, right? President Johnson Amnesty Proclamation, done at City of Washington, 29th day of May in the year of our Lord, 1865. Andrew Johnson. It talked about how the President of the United States at the time, what would have been Lincoln, had on the 8th day of December 1863 and 26th day of March 1864, did with the object to suppress the existing rebellion, to induce all persons to return to their loyalty and to restore the authority of the United States, issue proclamations offering amnesty and pardon to certain persons that had directly or by implication participated in the said rebellion. Well, that's really what's happening to us right now. We're considered enemies of the state. Whether we did anything or not, we're being considered an enemy of the state, taken to a military court that's got a gold fringed flag. Right? It's like a provost court or whatever they would have under military rule. And so, when Lincoln declared martial law in 1863, it's never been rescinded. And according to the Lieber Code, written at the same time, in Article 2, it says once martial law is declared, it doesn't go away until there's a special proclamation or a treaty of peace. Well, there never was a peace treaty, right? There was only an armistice, and there was never a proclamation. So continues the war. And so, we're being sitting on the wrong side of that by the government. But they gave us an out, and it's right here. I, Robert Allen Ratluski, do solemnly swear in the presence of Almighty God that I will henceforth faithfully support and defend the Constitution of the United States and the Union of States thereunder. Right? Not the AFL-CIO Union. No, the Union of the States thereunder. And that I will, in like manner, abide by and faithfully support all laws and proclamations which have been made during the existing rebellion, with reference to the emancipation of slaves. So help me God. Right? We're all supposed to be able to take that oath. It doesn't say in there that you were doing anything wrong. It's just you're swearing your allegiance. Right? It's a promissory oath. Well, then it went on in this next page to list all these people that it doesn't apply to. You know, D. Don't have time to go through all this right now. But at the end, it said the Secretary of State will establish rules and regulations for administering and recording the said amnesty oath so as to ensure its benefit to the people and guard the government against the fraud, or guard the government against fraud. So I have sent an online request to the State Department asking for these rules, but if somebody else has a better way of getting them, what is it we're supposed to do with this oath to have it properly recorded? Where do we need to go to? Who's the frickin' Civil War experts? Right? President Johnson's amnesty proclamation. Done. 29th day of May, 1865. So that's something else for us to try to get figured out. Because that would be the thing to do. Just take this oath here, go file it in the right place. And if you do this, you know, if you read the whole thing, you know, they give you back all your property. They're confiscating our property because we're seen as enemies of the state. Okay. Back in a second. Okay, so what about this Rule 40 petition? Let's look at that real quick. If you go to the Supreme Court of the United States website and go under Rules and Guidance, wait long enough, you get this thing here, and then you see these rules of Supreme Court, you know, the ones that are effective. And there's also this historical rules. So we'll be looking at, you know, both of those things in just a second here. But what those rules do then, this is what you would download, Rules of the Supreme Court of the United States. And Rule 40 is on page 60. All right, so let's look at page 60 where it says, a veteran suing under any provisional law exempting veterans from payment of fees or court costs may proceed without prepayment of fees or court costs or furnishing security, therefore, and may file a motion for leave to proceed on papers prepared as required under Rule 33.2, right? Drafted in a particular way, basically. The motion shall ask leave to proceed as a veteran and be accompanied by an affidavit or declaration sending out the moving party's veteran status. A copy of the motion shall proceed and be attached to each copy of the petition for writ of certiorari or other substantive document filed by the veteran. Okay, so where do you start? Right, this said petition for writ of certiorari. Well, a writ of certiorari is just one of many prerogative writs. Right, so if I can petition for a writ of certiorari, I should be able to petition for any other writ because those are writs out of the King's Bench. That's where the writ comes from, but you petition into the Court of Chancery. All right, you petition there to get the document to take over here to get it, whatever it is you need. That's how it seems to me. I remember my Blackstone from way back in the day when I was reading on Blackstone, right, about how the English common law works. Blackstone's commentaries on English law. That and Lord Coke's Institutus and the Laws of England or something like that. Right? Old stuff, old common law. Okay, and so I got to find a law that exempts veterans from payment of fees or court costs. Well, that isn't hard to do if you just, I thought I had this up here, right? But I don't have it. So what is it called? Equal. Hang on a second. Equal Access to Justice Act. Right? The Equal Access to Justice Act authorizes the award of attorney fees and other expenses to eligible parties who prevail against the federal government in judicial proceedings and certain adversarial agency adjudicated proceedings where the position of the government is not substantially justified. Right? So if the government is wrong and you have a grievance against the government being wrong and you're proved right, well, then you don't have to pay for it. And so this, criteria that they talked about in the law then is, well, if you take it to the right guy and he can see that you're right by you take it to the right judicial officer who looks at your petition and says, well, yeah, you're right, you do have a grievance, right? That they could go file this for you into the Supreme Court as an original action into the Court of Chancery side, not as a certiorari, but as a petition for redress of grievance. And then you pray for whatever relief you want. And if the court agrees with you, well, then they can write the order and you get it. It's not necessarily even judicial. It's all administrative. That's what the Court of Chancery is. It's administrative. It isn't judicial. The highest judicial court is the King's Bench. But the Supreme Court of the realm is the Court of Chancery. Because the Chancellor who sits of the Court of Chancery is the frickin' King's conscience. So it doesn't matter. This is just like you being found guilty and the president giving you a pardon. It doesn't matter that they found you guilty. The King's Bench found you guilty. The king gives you a pardon anyways. It's up to the king or up to the king's conscience, which is the chancellor. And that's why, it talks about in Rule 45 of these rules about process issuing out of this court in the name of the President of the United States, because he's the king's conscience. Right? He's not the king. We don't have an earthly king. This is a Christian nation. We have a Christian king. His name is Jesus. And Trump is supposed to be his representative here in the Christian nation of the United States. And everybody should be taking an oath on a Bible and kissing the Bible and all the shit I showed in my last video. But, the devil got in the details and he's mucked it all up and we need to go back and fix it. I'm just saying, if you're a veteran and you have some kind of claim, such as you're being persecuted by some other court, where the judge hasn't taken the oath that's in 4 U.S.C. 101, I guess I should pull it up too, because what the heck, that's what I do. I don't like to leave anything unturned. People complain my videos get too long. I'm sorry, man. I'm not leaving something unturned just because you're tired of watching. I want to make sure everybody understands where it came from. Rob Ryder doesn't say this stuff. I get it from them and want to say it back to them and say, well, this is what it says. How come you're not doing it? So in 4 U.S.C., United States Code 101, it says, every member of a state legislature and every executive and judicial officer of the state shall, before he proceeds to execute duties of his office, take an oath in the following form. To wit, I, Robert Allen Orlowski, do solemnly swear I will support the Constitution of the United States. Nothing else. Right? It says in the following form. This is the form it needs to be done in. There isn't, unless they alter the form, then this is the form it needs to be taken in. And the state can't alter this form because the federal government could alter it, but they didn't. This is what they said the state officer needs to do. If the state officer doesn't do this, then he's not a state officer as far as the federal government's concerned. He doesn't have any authority under the Constitution. And as I've been saying time and time again, from the person that calls themselves the governor on down to the dog catcher, including the judges and the sheriffs, the fucking police department, and the state legislature, and the attorney general, and the treasurer, and the county commissioners, and the township commissioners, and all these people, they haven't taken this oath. So they all are public officer imposters. Right? Now they're violating the penal code. It's just, who do you tell to get somebody to do something about it? That's why the problem. How do you get this resolved? So, but they haven't done it. And so I suggest, right, if you put in 4 U.S.C. 101, you'll see this govinfo.gov, right? If you go to here and do this one is probably better, and click on the PDF for 4 U.S.C. 101. It's just a one-page document. Here it is, right? There it is. Right there. Right? Print this out and carry it in your wallet. Go show it to anybody that you believe claims to have any authority, like go to a county commissioner's meeting or a township meeting or whatever, or just take it down to the township and give it to the people there and say, look, if you people have this oath, you don't have any authority. I thought you should know. Go tell the Pharisee the truth. Send a copy to every judge in your county. Send a copy to the sheriff. Send a copy to the police. Send a copy to the school board. Send it to everybody. They say, if you don't have this oath, you don't have any authority in the United States. You need to stop doing what you're doing. Right? You're warring with the Constitution. And, that's all you need to do. There's nothing else you can do. Either they're going to either God will work on their conscience and they will come to the realization that you are correct, or they're just devil worshiping pagans and there's nothing to do. They're going to, their soul's been damned anyways. But this is how you separate the wheat from the chaff. By an oath. Okay. Hang on again. Alrighty, so, I was looking, all this was started out was, well, here's the way that you pay for whatever happens under Rule 40 as a veteran is, you get your, as it turns out, counselor to accept this as the payment. That they're going to be paid by the government for representing your case because you were correct. It's just, what are you going to complain about? Right? So that's I'm going to just use some of my own experience as an example, but it could be anything. And one of the big ones for me would be, well, when I find the right guy, is I want to complain that Donald John Trump hasn't taken the 2 oaths of office that he needs to take, and so he's not president of the United States. And as an enlisted man, a veteran, my oath, which is still valid, is to the president of the United States, and there's nobody there. Well, then that's somebody's fault. Right? Because you're denying me my chain of command. In the military, we have an open door policy. I should be able to say, I want to go talk to the president and get a meeting. Okay, so this is the rules from today, right? But interestingly enough, if you went back and looked at the rules from the very first, this is on that historical section of the rules, right? This is the very first one. Volume 1. And I don't know why, but they skipped a year, right? It goes December terms 1801 and February term 1803. Well, what happened in 1802? Do we not have that year? But it talks about admission of attorneys or counselors as then being different, and that order that counselors shall not practice as attorneys nor attorneys as counselors in this court. That was the original rules, right? That there's 2 different styles of people, or officers, attorneys and counselors. And then in either case, they're going to take this oath. I state your name, to solemnly swear that I will demean myself as an attorney or counselor of the court uprightly and according to law, and I will support the Constitution of the United States. Okay. Now, this doesn't have to be the same as the one that's in 4 U.S.C. 101 or 1 Stat 23, which is the same oath, because they're not taking an office in the United States. They're just taking an office to represent you in a court of the United States. Okay, all process this court shall be in the name of President of the United States. So if you can get something out of this court, it will be in the name of the President of the United States, if it's a process, from the court. Normally all they're doing is, it's not a process that they're doing. They're just reviewing a judicial review of something that happened in a court below. So they're not issuing any process. They're just returning it. Right? We don't want them in that hat. We want them in this other hat where they issue process. That the counselors and attorneys admitted to practice court shall, take oath. February 5th of 1790 and August 8th of 1791. They put in the same order, saying about the same thing, just slightly different for some reason. Where was it down here? Okay. Inform him that the Chief Justice, in answer to the motion of the Attorney General made yesterday, informs him and the bar that this court consider the practice of courts of King's Bench and Chancery in England as affording outlines of practice of this court. Right? Well, in England, these are actually 2 separate courts. They're not the same court with the same people. The King's Bench has justices sitting on it, and the Court of Chancery has a chancellor sitting on it. Right? It's the King's conscience. Now, so actually, the Court of Chancery, it's an ecclesiastic court. These would have been the canons at the Westminster Abbey. because there's two courts that were always supposed to sit at Westminster Abbey, and one was the Court of Chancery, and the other one was the Court of Common Pleas, right? And then the King's Bench and the Exchequer went wherever the king was. Well, the king's gone, then they're gone, right? But the Chancery is still there. And we need to get a petition out of Chancery. Well, courts of Chancery don't use attorneys, right? They use solicitors in England. So, is that what as we'll see, that's what a counselor is today. Writ of error, writ of error, writ of error. What was there? Was there anything on this page? I don't think that there was. Oh, that counselors may be admitted as attorneys in this court on the taking of usual oath. So they're making it sound like counselors are different than attorneys. But when you look on this 2019 one, you search on the word counselor, you got each applicant shall sign the following oath or affirmation. I, state your name, do solemnly swear that as an attorney and as a counselor of this court. It used to say or counselor of this court. Now it says and. But who are the counselors of this court? That's all that really matters, because that's the hat we need them in. Even if it's the same person, just he needs to have his counselor hat on, not his attorney hat. No employee of the court shall practice as a counselor or an attorney as a counselor. Okay, so there is a difference. There is a difference. All right, just so I can say I covered it all, because I got the information sitting here. This is the form that they fill out as an application for admission to practice, Supreme Court of the United States. And the only place that used counselor on this page was right down here, where I put your name in, right? This is the oath of admission. Do solemnly swear or affirm that as an attorney and as a counselor of this court, I will conduct myself uprightly and according to law. So we just need to find the right applicant and say we need to have them in their counselor hat. That's the way it looks to me. And then this was the instructions for that, and basically it just says the same thing about the oath. And that's the only place it's using the word counselor in either of these is right here at the bottom. So I had emailed to the Supreme Court asking for a list of who their counselors were. I haven't heard anything yet, but it was just a quick thing to try. And before it's over, I'll probably have to pick up the phone call, or pick up the phone and make a phone call. All right, so let's read a definition here real quick. Seeing as how they talked about counselors, and I went into Bouvier's Law Dictionary, and there it talks about counselors at law. And it says a counselor at law, an officer in the Supreme Court, lowercase Supreme Court of the United States, and in some other courts who is empowered by a party in a cause to conduct the same on its trial on his behalf. He differs from an attorney at law, so it's not the same thing. We need to have him as a counselor at law, even if it's the same person. In the Supreme Court, lowercase Supreme Court now, of the United States, the two degrees of attorney and counsel are kept separate, and no person is permitted to practice both. It's the duty of the counsel to draft or review and correct the special proceedings, to manage the cause of the trial, and during the whole course of the suit to apply established principles of the exigencies of the case. Now, when they talk about duty of the counsel to draft or review or correct the special pleadings, that's what paralegals do. They draft legal documents, right? The attorney, he just, I don't even know what the attorney does, because they're not doing what we think they're doing anyways. But the person that actually makes a legal document is a paralegal. And so it's like, okay, well, these counselors, paralegals that are registered with the Supreme Court. Or can a paralegal register with the Supreme Court and represent you? I don't know, but that's what they are. Is this the person that draft or review or correct special pleadings, manage the cause on trial, and during the whole course of the suit to apply established principles of law the exigencies of the case. Generally, in the other courts of the United States, and as well as in courts of Pennsylvania, the same person performs duties of counselor and attorney at law. Well, it just said up here that in the Supreme Court they don't. Right? So, where's the Supreme Court? In giving their advice to their clients, counsel, and other professionals, and others, professional men, have duties to perform to their clients, to the public, to themselves. In such cases, they have thrown upon them something which they owe to the fair administration of justice, as well as to private interest of their employers. The interest propounded for them ought, in their own opinion, to be just or at least fairly disputable. And once such interests are propounded, they ought not to be pursued per fast et nefas. Well, they're saying a lot of shit there I don't really understand. I have to go back and read that some other time. But anyways, a counselor is not a hired person, but a mandatory. He does not render his service for price, but as an honorarium, which may, in some degree, recompense his care. So it's like, okay, well, that's what I'm talking. I don't have to pay him. The court will pay him for representing my cause, right? Because I was harmed by the state. The court agrees. Well, here you are, right? Thank you for bringing it to our attention. Doubtless he is not indifferent to his remuneration, but nobler motives influence his conduct. Follow him in his study when he examines his cause, and in court, on trial, see him identify himself with the idea of his client and observe the excitement he feels on his account. Proud when he is conquered, discouraged, sorrowful if vanquished. See his whole soul devoted to the cause he has undertaken. It's almost like this in an ecclesiastic office, right? Whatever it's a, right? Is this a canon lawyer in which he believes to be just, and you perceive the elevated man, ennobled by spirit of his profession, full of sympathy for his cause and his client. He may receive reward for his services, but such things cannot be paid with money. No treasure can purchase the sympathy and devoutness of a noble mind to benefit humanity. These things are given, not sold. We're not talking about your freaking ambulance chaser, right? Who is it we're talking about? That's who we need, the guy that takes the honorarium, right? Whoever gets paid by an honorarium, and he's a counselor, it sounds like he's the guy to use to get your business done in the lowercase Supreme Court of the United States. I'm sure he knows where it is if he has those credentials. Ridley says that the law has appointed no stipend to philosophers and lawyers, not because they are revered services and worthy of reward, not revered services and worthy of reward and stipend, but because either of them are most honorable professions whose worthiness is not to be valued or dishonored by money. Yet in these cases, many things are honestly taken, which are not honestly asked, and the judge may, according to the quality of the cause, and this, I'm going to say it's supposed to be skill of the advocate, skill of the advocate, and the custom of the court, and worth the matter in hand, appoint them a fee answerable to their place. Well, that's what they do under the Equal Access to Justice Act. Honorarium, payment made as a matter of honor, and not because it is due as a legally enforceable debt. Honorarium, a recompense for services rendered. It's usually applied only to the recompense given to persons whose business is connected with science as a fee paid to counsel. It is said this honorarium is purely voluntary and differs from a fee, which may be recovered by action. See Counselor at Law. Well, that's what we're looking at. Recompensation when a party sues for a debt and the defendant pleads compensation or set-off. Plaintiff may allege compensation on his part. This is called a recompensation. Well, I don't know that we're under Scottish law. We're under English law, right? So I guess that one doesn't apply. a reward for service, remuneration for goods or other property, or then in maritime law, there is a distinction between recompense and restitution. Whether goods have been lost by jettison, So it applies under maritime law also. Right now, we're talking about a court of admiralty. I don't know. Recompense and recovery in value. This phrase is applied to the matter recovered in a common recovery. Wow. Well, a common recovery is what you're supposed to get under the Cesta KV Act. Right? You're supposed to appear before the proper magistrate. They're going to take you somewhere and do a common recovery, which is really not a court case as much as a little act in a play. After the vouchee has disappeared, judgment is given to the demandant. It was all covered in Blackstone back in the day. I don't remember it all. And philosopher, because they said there were two, a lawyer, right, and a philosopher. So what's a philosopher? A person who offers views or theories on profound questions in ethics, metaphysics, logic, and other related fields. So maybe we need a philosopher to take. We don't need an attorney. We need a freaking philosopher. A person who's deeply versified in philosophy, establish central ideas of some movement, cult, etc. A person who regulates his or her life by the light of philosophy or reason. A person who is sensibly calm or rational, especially under trying circumstances. Whoever can get the job done. Then I talked about whatever it is, that it's a mandatory. Well, what's a mandatory? A person to whom the Pope has, by his prerogative, given a mandate or order for his benefits. One to whom a command or charge is given in law. One who undertakes without recompense to do some act for another in respect to the thing bailed to him. Well, then this is why I'm saying, well, it can't be in law, it must be in equity. Because what we're talking about is somebody who's going to get recovery, an honorarium. Right, as a counselor at law. He gets an honorarium, which is a thing down here, which is a recompense, which is a thing that they say you don't get in law. So he must work for a fee in law and honorarium in equity, which is what the Court of Chancery has jurisdiction over. Okay, so again, this is just out of Bouvier's Law Dictionary, counselor at law. Right? What's a counselor in government? Is a member of a council. In some of the states, executive power is vested in a governor or a governor and lieutenant and council. The members of such council are called counselors. See the names of the several states. Okay, let's get specific now to the Rule 40 I was speaking of. Okay, hey, if you're a veteran or you know a veteran and they may not have this, why don't you do this for them? Go to this website, which is militarypay.defense.gov. Right? Military, military, pay.defense.gov. And you'll come to military compensation. If you go into the pay tab and go down here to where it says recoupment and click on it, you'll see that it has this SPD codes. And this code is the thing that shows up on a DD-214 down here in the separation code, which mine is JBK on this particular DD-214. Like I said, I have two of them, and they both have different separation codes, but both of them then by this list that you download, right, that mine's JBK. I thought it was right here on the first page. What's JBK? JBK, right there. Completion of required active service. So in this block E, it says yes, 10%. Well, what the heck does that mean? Well, it means I should have got separation pay, right? I was eligible for separation pay. And so anybody that has a code on their DD-214 and block 26 that has a yes, right, next to it, well, you were supposed to get separation pay. I never got it. Right, and this is part of my, my theory is I've never been separated from the military. Before it was just based on the fact I didn't have a separation order, but now I can say, well, you didn't pay me. Right, so I got paperwork going in right now to the DFA, is it DFAS? Defense Finance, something or other? trying to get it figured out. But it's like, I want to go file a claim with the Supreme Court and say that I haven't been paid and that they're dicking around, won't pay me, right? I'm going to say I have a grievance, right? So I don't want to sue them. I want to petition for a redress of grievances to the government to say the military never gave me a separation order, didn't give me my separation pay, and I'm supposed to be paid, right? And all I need to do is find the guy to put the paperwork in. So, it's not a difficult argument to make. It says JBK. I can go to JBK, and JBK says I should have got separation pay. I didn't get it. Now, the other thing on mine, right, because everybody's is different, but they all have errors in them. I've done a number of videos on these, and I'll do a much better one than this on this particular subject, but I just want to cover it today in this video. Right, mine says command to which transferred, NA. Well, under the regulation that covers this thing, and they put NA in that box. In fact, I'm going to show you because I can. Just hang on a second. Okay, so this will be different for every service branch, right? But Army Regulation 635-5, personal separation documents. If you're in the Army, you've never downloaded this document, you should do it. And, you just need to Google Army Regulation 635-5. This explains what goes in each of the blocks of a DD-214. And I'm not going to go into the whole thing right now. I'm just saying that that's what it does, right? And completing the DD-214. Okay, so at some point we get to block 9, command to which transferred, right? From DD Form 214, item 9, entry determinations, table 2-1. Okay, so whatever's in the table, which is here at the end, right, table 2-1, and there's only a couple of places where they put NA in, and one is that there's no further military status, which is what they would like me to think I am now. I don't have a military status anymore. Well, for that to be true, I would have to have had a DD-214, separation pay, a discharge certificate, and a separation order that says that I've been released from the custody and control of the military. I don't have one. Don't have separation pay. Never happened. So that can't be what it's for. Well, what else can an NA be for? Well, I've been placed on the AUS, which is the Army of the United States retired list, and not transferred to the retired reserve, applicable to the RA enlisted, or revert to AUS or USA retired list status. You get an NA because you've been retired, right? I was disability retired. That's what I believe happened to me. And I think anybody else that has an NA in your block 9 of your DD-214, right, that this is evidence that you've been retired. And that pay is going through the government. It's just not coming to us. It's our pay. It's in our name. We've been retired. But it's going into this military retirement trust fund, right, which has over $1 trillion in it. Right? Military retirement trust fund. Right, and you can download this audit report, and I've done videos on this, and you'll see in here it talks about it having over $1 trillion in it. Well, why is there $1 trillion in a fund that's funded every year by Congress with more than enough money to pay all the retirement? It's because not all the retirement's being paid out to people. It's being put into this trust fund for whatever reason, like they don't know where we are, or hey, we owe them $25 because we got paid too much one time, or whatever the error or omission is in the record that's keeping it from going to us. And this is for everybody in the military, right? There's no veteran enlisted man that I can think of, or woman, that's ever been released from the military. Right? We should all have an ID card, and we should all be getting paid because they never let us out. And it's on your DD4 agreement. Right? This is the agreement we all sign, enlistment, reenlistment document, where we took an oath of office, which has on here. Where's the oath at, Bobby? Right here, right? National Guard or the Armed Forces, except the National Guard. I state your name. Do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, and I will bear true faith and allegiance to the same, and I will obey the orders of the President of the United States and the orders of the officers appointed over me according to regulations and uniform Code of Military Justice. So help me God. President of the United States. That's why it's so important that we have a President of the United States as an enlisted veteran. We're supposed to take his orders. It's our duty. So, the fact that somebody's saying that they're the president and aren't actually the president is a big deal. I'm all for Trump being president. Just take your oath to office, Trump. But in here on the second page, right, this is the back page. It talks about all these reasons you could be kept in the military, which, but if you are, you're entitled to receive pay, allowances, and other benefits as provided by law. Right? I understand that I can be ordered to active duty at any time, and while I'm a member of the DEP, and in a time of war, my enlistment may be extended without my consent for the duration of the war and for 6 months after the end of the war. That's in Title 10, United States Code 506 and 12103C. Well, that's what's happened to us. We're freaking, we're always at war. The United States is always at war. War on drugs, war on terror, Cold War, World War II, World War I, Civil War, Spanish War. Anywhere the word war is a war. If it's an armed conflict, it's a war. It all counts. And so, because we signed this agreement and they decided to extend us, which they could do, they owe us pay because they're required to pay us, entitled to receive pay, allowance, and other benefits as provided by law and regulation. So they are paying us, and that money's going to this retirement fund or some other similar fund, right? That's just the one that's most obvious to see, but I'm not saying there aren't other funds where other money's going. It's just the shit that's going on. So, anyways, that was what I wanted to talk about today, right? Counselor at Law, SCOTUS Rule 40, Veteran Petition. I need to find a counselor at law. If anybody knows of one or somebody wants to step forward who is one and, do some business, let's go. Contact me at 616-712-6179. Send me an email at courtofrecord@AOL.com. Send me a letter to Robert Allen Lusky, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. But get a hold of me because I want to file a claim into the lowercase Supreme Court of the United States. So this is the thing about this SCOTUS that bothers me, right? After you read the definition and then you go look at the rules they had for this SCOTUS, this talks about them being both. Right? So like SCOTUS really isn't the Supreme Court of the United States. An attorney and as a counselor. That as an attorney and as a counselor. Are these separate? What's the grammatical breakdown of this sentence? Are they talking about two different offices, two different people? Or is this the same person wearing two different hats? Right? Because it isn't the way I said it in the beginning. Now this says attorney or counselor, right? Like there's a separation. So smoke and mirrors is always in the way, right? I solemnly swear that as an attorney and as a counselor. It doesn't say or as, which is what it said originally. It used to say or as a counselor. Right? As an attorney or counselor of this court. At some point, they changed the frickin' grammar of the sentence, and I don't know why, and I don't know exactly what it means, but what I know is that according to the definition of the counselor at law that, when it's talking about the Supreme Court, that's where counselors at law are, and they're not the same person. No person is permitted to practice both. In the lowercase Supreme Court of the United States, 2 degrees of attorney and counsel are kept separate, and no person is permitted to practice both. Okay, so I need a counselor at law that can practice in the lowercase Supreme Court of the United States. And if we had that, we could take care of all the problems in the United States immediately. And we don't have to pay them, right? They get paid by the court. It's an honorarium, right? It's all here. Counselor at law and Bouvier's. Okay, I'm done. Y'all have a good day now. See ya.